right, ladies and gentlemen, good to see you guys once again. Filming live from my parents' home in Gastonia here visiting. But today we're going to talk about Chapter 7 Inspections and Regulatory Searches. All right, core concepts and summary statements. As a basic introduction, administrative inspections enforce agency rules and regulations in regard to building codes, immigration, fire, and worker safety, and other matters, and also other matters, and require warrants based on a modified probable cause standard. So with inspection and regulatory searches, we're talking about those industries that regard safety, stuff like food, and of course with specialized industries like restaurants. Of course, that's why the health inspector can come in your restaurant and make sure that you're up to code. So we're talking about stuff like that. Special needs searches do not serve the ordinary needs of law enforcement and are not designed to gather evidence or to investigate a crime. These searches typically require reasonable suspicion or do not require any articulable suspicion whatsoever. So, first and foremost, administrative inspections. Government agencies conduct searches of homes, businesses, and factories to check on compliance with government regulations. These regulations cover health, fire and worker safety, environmental measures, and housing codes. The Supreme Court held in Camera v. Municipal Court that the government interest in administrative inspections of the home outweighs an individual's privacy interest and accordingly requires only a modified probable cause standard for an administrative search. In C or Save v. Seattle, the Supreme Court moved that the inspection of commercial enterprises based on a modified, they approved, um, inspection of commercial enterprises based on a modified probable cause standard. Probable cause and warrants are not required in the case of closely regulated businesses. This includes junkyards, automobile dismantlers, liquor dealers, gun stores, and power plants. Special needs searches. Special needs searches involve two steps. First is the search based on special needs beyond the normal needs of law enforcement. Second, the court balances governmental interests against the intrusion on the individual interest to determine whether the search requires probable cause, requires reasonable suspicion, or may be undertaken without articulable suspicion whatsoever. Special needs searches have been relied on for border searches, airport screening, workplace drug testing, school drug testing, physical searches of students, and searches of probationers, parolees, and prisoners, and all of which we'll touch on today. So all those fall under the special needs category. So international borders, and of course, this is a hot button topic these days because of what's going on politically. But suspicionless stops and searches by roving patrols are lawful at the border or at the functional equivalent of the border. Stops outside the narrow confines of the border must be based on reasonable suspicion. The border exception to the Fourth Amendment authorizes warrantless routine searches at the American border or its functional equivalent without reasonable suspicion. Routine searches include the search of luggage and persons. Non-routine border searches entail intrusive searches such as strip and body cavity searches or x-rays. These searches intrude on an individual's dignity and privacy and require reasonable suspicion. So the regular search of a vehicle just to make sure it's not necessarily contraband or contraband and maybe people that aren't supposed to cross the border is one thing, but searching a person's body, cavity searching them, of course, that requires more. That requires probable cause at that point. Motor vehicle checkpoints. Stops of automobiles by roving patrols outside the area of the border require reasonable suspicion. Um, Automobiles may be stopped at checkpoints on the U.S. Mexican border without reasonable suspicion or probable cause in order to protect the territory of the United States. Checkpoints may be employed in the United States in the interest of highway safety. Checkpoints whose primary purpose is to detect ordinary crimes are an unreasonable intrusion on individual privacy. And I'll go back to that because I think the book kind of overgeneralizes checkpoints. So, in that section, it talks about two types of checkpoints. It talks about the checkpoint at a border, which of course the law gives them a little bit more leeway at the border. But there's also that checkpoint that happens just every day. Checkpoints in the city of Greensboro, which is nowhere near the U.S. Mexican border. The police are allowed to have those checkpoints just for motor vehicle safety, but they have to actually post it in the newspaper or post it publicly, make notice, give notice to the people that there is going to be a checkpoint and where. So most of the times when you see these checkpoints in Greensboro, not even most of the time, all the time, that somewhere in the newspaper that's been posted. As a matter of fact, they have apps that'll tell you that there's a checkpoint is certain points at night. But they may be employed in the United States in the interest of highway safety. So it's supposed to be about highway safety and not detection of crime. So it's really supposed to be about making sure your car's up to par, that you have registration and that you're driving a safe vehicle. It's not about detecting crime, even though that's really what it's about. Checkpoints whose primary purpose is to detect ordinary crimes are an unreasonable intrusion on individual privacy. Um, Good luck with that in the courts because very seldom do the courts actually find checkpoints, even though we know when they set up these checkpoints, it's really about trying to find drunk drivers. That's really what it's all about these days. Um, so, for the most part, even though we know they're for the purpose of detecting crime, as long as they announce it and say, "Oh, it's just about safety," they get away with it, even though they're really doing it to detect specifically DUIs. They want to get as many DUI arrests as possible, which is understandable. I don't want to sound like I'm negative, but you don't want drunk drivers on the road. But it's a fine line between that and the hysteria that's been created behind the politics of DUI. I'm just saying that. So everyone they pull over, they want to charge with the DUI. So they want the more checkpoints they have, the higher the likelihood is that they'll pull somebody over and charge them with the DUI. Okay, airport screening. Courts have recognized a special need to X-ray carry-on baggage for weapons and explosives, and to subject passengers to both pre-boarding walkthrough screening and a handheld magnetometer or wanding without reasonable suspicion. And that's one of those things where we say thanks, Bin Laden, like the movie, the movie Hangover. One of those things that happened, of course. You guys, the students, are younger, but there was a time where you could walk in the airport with the person you were dropping off, park, walking them all the way to the gate. You didn't have to go through security. I remember my brother going to the military when he was leaving for Japan. We actually were at the gate where he was boarding the plane. Like we walked straight in, and we didn't have a boarding pass. But of course, that was in the late '90s, before the terrorism and the stuff that happened on 9/11, which changed everything. So of course that was back in the day, but now because that happened, airport security is at an all-time high. Of course, if you don't have a boarding pass, which essentially means you're not there to get on the plane, you can't go past a certain point. So you have to have a boarding pass. They check your boarding pass. They check your whatever carry on you're gonna have. Of course, even if it's not carry on, if you're checking the bag, of course, you give them that check bag if you don't think they're going through it, or that it's subject to be going through anyway. But they definitely pass it under machines and metal detectors to make sure there's no explosive. Of course, they have dogs out there and everything, but definitely to get to board a plane as a human and to have a carry-on bag, they're gonna search you, have you do everything that we know they do to you in the airport. I think that's kind of we know what goes on in the airport when you're trying to fly. Workplace drug testing. The Supreme Court upheld workplace drug testing of railroad employees following an accident, and that's in the case of Skinner v. Railway Labor Executives Association. The government has a strong interest in regulating the conduct of railroad employees involved in safety sensitive activities in order to protect the railroad traveling public. So, in certain industries like railroad safety, even airplane, and with pilots and stuff of that nature. and certain other industries that affect commerce, like our ability to go back and forth as Americans and have things, our packages mailed and shipped and stuff like that. The government has a very has an interest in protecting that, protecting the sanctity and the movement of goods and people. So if there is an accident or some type of workplace incident, that's when the government and their agents can come in and do drug testing. Now that's separate from an agency, that the agency that you're employed with. So, um, so that was the government doing workplace drug testing. But when you sign up for a job, so let's say I have a buddy that does. He's a forklift operator, and he actually had an accident on the job. And of course, the first thing they do as a part of his employment there, if there's an incident, they had to submit themselves and give a urine and blood sample, I think, to make sure they weren't intoxicated. So with that, that's not necessarily the government. That's not at all the government making him doing it. That making him submit himself to a give a sample or be drug tested. That's actually the employee. So there's a difference between that and the government. So they're not doing it in furtherance of they're not doing it necessarily in furtherance of criminal investigation that is going to be used against you to incriminate you. They're doing it because they're the boss and you're the subordinate. So you're working for them. So they're making sure um, they're actually trying to cover themselves from liability. So that, of course, when these things happen on job or incidents happen, they want to find ways to blame it on somebody else. So of course, if you have been taking drugs and someone gets hurt on the job or you get hurt, they can say, well, he showed up to work, he was drunk, or he has marijuana in his system. Therefore, it's contributory negligence. So he was part of the problem. So we're not going to pay him out anything. We're not going to pay his disability, stuff of that nature. So that's what that's about. And normally in those situations, you've already waived your right to not be drug tested because you signed that employee contract. So people don't realize when you get these jobs at these places, you have to pay close attention to that packet they give you when you get that job. You're signing a whole bunch of stuff. You're also signing certain rights away, and this that wrong. So they're rights, but it's not rights. The rights you have with the government or against the U.S. government or law enforcement, because it's not really law enforcement; it's a private agency that's hiring you. So as a part of your hiring process, you coming on to work with us, you're giving us permission to search you to essentially search your body. So if something happens, you got to pee in the cup, and that's what it is. So refusal to pee in the cup would be grounds for termination. So most of these people in these situations want to keep their job, so they pee in the cup. And of course, the company, depending on what happens after they pee in the cup, the company moves forward, however they're going to move. But that's what that's about. So, but in those railroad cases, that was actually the government, the federal enforcement, where they were actually doing um, employment drug testing because of the industry they were in, because it was an industry that affected transit and affected. So the railroad industry has always been, back in the day, that was the only way you move outside of horse and carriage from state to state. So railroad is very important. That's how our freight, that's how things get from place to place. So the federal government has always had an interest in making sure that certain industries, because goods and services and commerce, because of commerce, they want to protect those industries. So if there is, so they kind of step in and perform those drug tests in those situations. So that's what that's about. So I want you to know the difference between just regular employee drug testing and the government actually stepping in and being able to use the results of that drug test against you criminally. So searches in high schools. So let's move on. Yeah. Searches in high schools. The Supreme Court held in New Jersey v. TLO. And of course, you see TLO is an abbreviation for a name. So we're talking about a minor. Anytime you see a case and they abbreviate a name in the case heading itself, that means it's probably a minor we're dealing with. So they're not going to put the minor's name out there. So in the Supreme Court they held in New Jersey v. TLO that the Fourth and 14th Amendments protect students against unreasonable searches and seizures by public school authorities. Reasonableness, however, in the context of student disciplinary investigations is not a matter of probable cause. The reasonable suspicion standard, according to the Supreme Court, is as opposed to probable cause. Remember, reasonable suspicion is lesser than probable cause. But the reasonable suspicion standard, according to the Supreme Court, relieves school personnel of the burden of learning the niceties of probable cause. So you're not talking about cops in these situations. You're talking about school personnel, and they're searching students or making sure the school's safe. So rather than have them know what probable cause is, which no one knows, um, they apply a lesser. They said a lesser standard, which is reasonable suspicion, is all right, and that's a good basis for them to be able to search a student. And it ensures that searches will be carried out in accordance with the dictates of reason and common sense. And Vernonia v. School District of in let me see. In Vernonia School District 473 versus Acton, the United States Supreme Court upheld the random drug testing of student athletes. That's one thing about the school system. So, as of course, this is before we get to college. We'll talk about that as well. But in elementary school, I guess secondary school, secondary in your secondary education, first through 12th or whatever, in the public school system, does anybody remember when the fact that law enforcement could come in school to to have the dolls come and smell lockers? Now I went to a high school where people might sell and smoke weed. I don't know where I went to high school, but that's what happened. Uh, here and there in my high school. I definitely saw people get arrested in high school for having weed and stuff like that. But when you're in that school, your parents have essentially given them at least what I would call temporary custody of their children. It's like here, you're tasked now with keeping these students safe. So part of that safety is that they have to make sure that students aren't putting other students in unsafe situations or bringing things to school that can make it unsafe for everybody. So that's why they allow schools to do searches. So of course, if no, we're not talking about law enforcement. We're talking about school personnel. So I'll read it again. Um, but the TLO case held that the Fourth and 14th Amendments protect students against unreasonable searches and seizures. So you're still protected from unreasonable search and seizure. So it still has to be a matter of reasonableness in the search and seizure, and that's by public school authorities. But they can search you. The reasonableness, however, in the context of the student disciplinary investigations, is not a probable cause standard. It is a reasonable suspicion standard. So in high school, they still have the searches they perform still have to be based upon reason. They have to be reasonable. They just can't randomly say, "Hey, we're gonna run your pockets." It has to be based on something. So and that something is instead of it being probable cause, it's now reasonable suspicion. So it's just the lower standard. So it's not like they can just randomly search the students at a school. They have to have a reason to do it. But they are allowed to do it, even though they're not law enforcement, because they're tasked or they have the duty of keeping students safe and keeping contraband out of schools. Also, student athletes. And then that second section where we talked about the random drug testing of student athletes. Of course, once you are a student athlete, you've kind of waived certain rights because you put yourself in a position where um, through competition committees and things of that nature, they have to make sure that you're not taking performance enhancers. So that's another thing with the NCAA. That's why NCAA athletes. I may have some athletes that are in this class this semester, but of course, every NCAA athlete, they know that at some point in time they're going to get tapped on the shoulder, like, "Hey, come with us. We're just going to randomly have you urinate in a cup. We're going to make sure you haven't been taking any performance enhancers or any drugs that are banned." So, of course, by virtue of that scholarship or you want to be an athlete on the collegiate or even in the high school level, you may be subject to drug testing. So that's what that means, and that is constitutional. So what you've done is you made a choice. You say, "I want to play." Well, if you want to play, you gotta be willing to possibly give a drug sample or sample. So that's what that means. Probation and parole. In Griffin v. Wisconsin, and well, let's talk about the special status of a person on probation and parole first. So when a person is on probation, so when they read out a sentence in court, when they put someone on probation, here's how it normally sounds, at least in North Carolina. The judge says, I sentence this person to, let's make it a misdemeanor. I sentence this person to 120 days in the Guilford County Sheriff's Department. That sentence is suspended. At that point, that means the sentence is that the person is not going to serve the active sentence, the full 120 days. So when they say that sentence is suspended, they've now suspended the sentence. And I'll tell you what suspension means. But they say that sentence is suspended, and I'm placing the defendant on supervised probation. And then they name out the list of conditions that they have to meet while they're on supervised probation. That may be, let's see, that may be a community service requirement. They may have to take GED courses and obtain a GED while they're on probation. Of course, there's always the random drug test. So what happens with that suspension, and I don't know if you can see over my head, but it's almost like having a boulder. The system has a boulder, a huge rock that is now, and that huge rock is at 120-day sentence that is forever walking above this person's head. Everywhere they go, it is suspended or being held by a small string above their head. At the moment they violate probation, they do something that they're not supposed to do according to what the judge says their conditions are, they violate a condition, they can be brought back to court, and that string can now be cut. And that means that boulder that is 120 days is dropped over their head. So that's how I explain suspension. So the sentence is suspended. But while the sentence is suspended, they're placed on supervised probation. That's how probation works. Parole, a little bit different with parole. So probation is before jail. So instead of you going to jail, we're going to bypass jail. We're going to put you on probation, jail or prison. So incarceration, I use that one word. So parole is different. Parole means you've already been incarcerated, and we're going to let you out early, or we're going to let you out on a condition that you act right. So it's still the same thing. So we're going to give you. So you've been in jail 15. So you might have a 20-year sentence. You get out of jail in 7 or 8 years. You make parole after 7 or 8 years. So in other words, we're going to to kind of stem the tide of the prison population. We're going to let you out of jail. You're going to have an officer, a probation officer. They call them parole officers, but they're the same thing. Probation, as a matter of fact, in North Carolina, it's all run through the Department of Health and Human Safety, and it's called the Department of Adult Corrections. So that encompasses probation and parole officers. They're the same thing. So what happens is, with parole, which is different than probation, you've already been in jail and we're letting you out early. And if you act right, you don't have to worry about serving the rest of that time you're supposed to do. So you get out and you're on probation, and you have a probation officer, or you're on parole. Don't want to use them interchangeably, but you're on parole, so you have a parole officer. So in both of those situations, however, the one thing they have in common is whether you're on parole or probation, you are still property of the Department of Adult Corrections. Anybody ever see, I know you see the movies where they have people say their prison ID number, their number, they stand there and they take the picture and they say, I think it was Malcolm X, that movie where they say, "Little, say your name." And he had to say his name. He didn't say his name, so they put him in solitary confinement. But what's crazy, whether a person is actually in prison or not, they may be on probation or on parole, they have a number. So I used to represent people on probation violations. You look at their probation violation, and there's a number. That is their Department of Corrections number. So guess what? If they do get arrested and sentenced on that probation violation, and end up having to go to jail, the number they're going to have to read out as their number is that number. So what that means is you still have it's almost like a warehouse receipt or a receipt number. So when you're on probation or parole, you're not really free. You're kind of conditionally free. So you don't really have freedom. So I wanted to preface this next section with that before I got into it, and let you know why the court kind of sees these things the way they see it. So in Griffin v. Wisconsin, the Supreme Court upheld the constitutionality of the warrantless searches of probationers based on a reasonable suspicion that the individual was violating the conditions of his or her probation. The court explained that the reasonable suspicion standard permits probation officers to intervene at the first signs of trouble rather than wait to develop probable cause. The United States v. Knights, in that case, the court upheld the warrantless search of a probationer's home based on reasonable suspicion of criminal activity. And what happens is in court, when they read out a condition, the judge reads out a condition, they say, and you're subject to warrantless searches. Now, all that means they don't have to go get a warrant. The search still has to be reasonable. So being on probation doesn't mean that the searches don't have to be based on reason. They still have to be reasonable searches. They just no longer have to go get a warrant before they search you. That's what it means. So it doesn't mean they can rough you up or do anything crazy just because you're on probation. So their search or their seizure review still has to be based upon reason, and it has to make sense. But they just no longer have to go get a warrant. And actually, it honestly still has to be based on at least some standard, reasonable suspicion. So what happens though, because when you're on probation, you're essentially agreeing not to go to jail today, and when you're on parole, you're agreeing not to be in jail anymore. Like, I want to leave out of here, and in order to leave out of here, I'm cool with being searched every month. So it's like a contractual relationship where you're contractually giving up certain your Fourth Amendment rights. So in return for not being in jail, you're going to be out here with everyone else with society. You're going to be free, but there's certain things you got to do, and you're going to be subject to certain things. That means, matter of fact, warrantless searches. You have to give blood and urine samples. So that's why people have to go to their probation or parole officer every month. They have to pee in the cup, make sure they're not using any illegal drugs in certain situations. They got to get blood or whatever to make sure that they have consuming any illegal substance, because that's also usually a part of probation. That's always one of the conditions of probation. So there is a lesson standard or a lesson burden when it comes to the searches of probationers and parolees. So just remember that. Now we're going to talk about correctional institutions. Pretty much the same thing. But of course, when you're in a corrections institution, instead of you being out looking like everyone else, now you're actually physically in their custody. So there's no suspension of a sentence, or there's no parole sentence to suspend it over your head, where you may have to go back in. Now you're actually in their custody, so you really don't have much rights at all. Because when you're in prison, that prison room that you're in, and that bed, that cot that you're inhabiting, is not yours. That is the property of the state or federal government, and you're just borrowing it. So in that room they put you in, that cell they put you in, is not yours. That is theirs, and they can search it at any time. And that's kind of the sentiment behind these rulings. But in Hudson v. Palmer, the U.S. Supreme Court held that inmates have no expectation of privacy in their cells, none whatsoever. So that means not only do they not have to get a warrant, but and all these things are supposed to be reasonable. So the reasonableness of searches never goes away. But definitely this warrant requirement, there's no expectation of privacy whatsoever in a jail cell that is not yours. You don't own that. So they can run that jail cell, they can ransack it, search for whatever, make sure you're not trying to escape like Shawshank Redemption. They can do all that. In Bell v. Wolfish, the court approved visual cavity inspections of pretrial detainees or inmates returning to the cell block from a contact visit with an individual from outside the institution. These searches were viewed as reasonable because of the need to deter smuggling of weapons, drugs, and other prohibited items outweighed the intrusion into an individual's privacy interest. So pretty much what the court says there is, at least in a prison or jail cell, there's no individual expectation of privacy. Also, partly it says that when you're in prison, you almost don't have an a reasonable expectation of privacy, really, in your own body, depending on where you're coming from. So if you're just in the jail cell, they can't just randomly do cavity searches just because you're there. But when you've been transported from one place to another, when you've been outside and you're coming in, Anywhere where things can happen, weapons can be bought in. At that point, you're subject to have, and not even just subject, they're probably going to cavity search you. It just is what it is. They don't have you bend over and spread them and stuff like that. So that's what that means. Also, another thing I had to say about cotton, this isn't in the book, but it's kind of a part of our discussion. You guys being college students, another place where you have a lessened amount of constitutional rights is in a dormitory room. So, of course, A&T, of course, is a state school, but at any school, you're not, just by virtue of being a student living on campus, that is not your dormitory or residence hall room. That is A&T's. You are contractually linked to it, so they're allowing you to be there. But that is their room. That's why if you have a RA, the RAs have a master key to everything. They can come in your room, and now they're not supposed to come in to detect, for a crime investigation, but they can come in to make sure you're living up to code. In other words, they always say you can't have a hot plate and stuff like that, or certain things that are prohibited because it affects the safety of the whole building. We don't want the building to burn down because you got a hot plate, or you using your George Foreman grill to make burgers, and you don't burn us all out. So they can come in to make sure you're up to code. Now they can't come. They can't just randomly come in because they're searching for drugs. That then crosses over into law enforcement. Now, law enforcement, they can come in if they feel like they suspect, but they do have a standard. So in most schools, they still go get, even though it's their dorm room. It's the university's dorm room. University police are usually still going to go get a warrant, if it's in furtherance of a criminal investigation. So there's a difference between them searching in furtherance of a criminal investigation and them searching just to make sure that you're up to code, like what we've been talking about, regulatory searches. So they want to make sure it's a regulatory situation where they want to make sure, of course, your dorm rooms and campus safety is a regulatory issue on the college campus. So they want to make sure that everything's right. If you're living in not Scott Hall's not there anymore. I'm gonna tell you how old I am. But if you live in Cooper Hall or Pride or wherever, those RAs and that campus housing staff, they have the right, matter of fact, the permission to make sure that you're living up to code and you don't have anything that's going to hurt everyone else or something you're not supposed to have. Now, of course, in these situations where they may find something that at that point, if your RA's searching under your bed to make sure you don't have a hot plate, and they see a kilo of weed or cocaine, at that point, now they can go alert officers, and based upon what they're saying, that can give rise to probable cause for that officer to now go get a warrant and search your room. So that can happen. So just remember that. So for idiots that want to do dumb stuff on college campuses and say I'm just smoke weed in my dorm room, you do realize that they can just come in your dorm room. That's not your house. They don't, now of course if they're not rude, they'll not, but they don't necessarily have to. So just be cognizant of that. There are not many Fourth Amendment rights that you have on a college campus, at least in college facilities when you're living in a residence hall. So, but that's just something I added to chapter 7. But that's chapter 7, of course. My These online, and even if it wasn't online, but these lectures are essentially just kind of supplemental. You still need to read and study the book, look at these cases and look at stuff in the book. So I don't want you to depend on just my lectures. Just read through the book, realize what's going on, do review questions. So you still have to do the work. So don't lean on me to just tell you everything. So that wraps up chapter 7. So we'll do chapter 8 next. So you guys be good. Thank you. Take care.